Over the past week, the prosecution has introduced a number of people with different vantage points the night Zimmerman shot and killed unarmed Trayvon Martin. Some may have helped make the case for the second-degree murder charge that Zimmerman faces, but some may in fact have created reasonable doubt needed for an acquittal. Joining me now to talk about what we have heard and seen so far and what is to come is Tariq El-Shabazz. He is a criminal defense attorney and former prosecutor, and Jelani Cobb, who is the director of the Institute of African American Studies at the University of Connecticut. Hello, gentlemen, to both of you. Thank you for being patient with us. We appreciate this. And let's pick up with this thread of conversation about this is still the prosecution's case.
Absolutely.
These are the prosecution's witnesses, but all of these witnesses don't seem to be doing the prosecution a whole lot of favors.
Well, what you have to understand is they have the burden of proof, so they have to prove everything. What is better than to put out what is weak in your case in chief, as opposed to allow the defense to put it in as if you're hiding something? The fact that George Zimmerman was on top at one time and Trayvon Martin was on top at one time doesn't make a difference in this case. The fact that you can't make a determination scientifically as to whose voice it was really doesn't make a difference, and it doesn't bode well, I would submit to you, for Zimmerman. Why? Zimmerman wants to convince everyone that, in fact, he was defending himself. In fact, that's what his claim is, self-defense. How can you do that? Best to have my voice, Zimmerman, yelling for help. He can't do that either. So now we have a mother that's going to take the stand and says, the voice of that 17-year-old son is somebody that I gave birth to 17 years ago. That's my son's voice. It's a young-sounding voice. And the jury having to make that determination. We have to remember that a trial is like a boxing match. You don't fight and not get hit, unless you're Floyd Mayweather in certain cases. But in a real live situation, there's evidence that helps you and evidence that hurts you. So you're going to get hit a little bit. And they got punched a little bit. It's okay. Trust me, we shouldn't panic. It is okay. In order to have self-defense, even self-defense, they have to demonstrate, George Zimmerman is, that he didn't have the ability to retreat. Remember, stand your ground is not part of this case. So he didn't have the ability to retreat, and he used deadly force. Clearly, he's following. We have to focus, folks. Let's focus on what's going on. He's following Trayvon Martin, not only in the car, but outside the car. He was told not to pursue him. He pursued him, and in fact, we would submit to you the evidence shows he grabbed him. Trayvon Martin beat him up, so what? He's fighting for his life. The fact that he has bruises on him or his head is bleeding, it doesn't do anything other than suggest that Trayvon Martin at that time was fighting for his life. So I think that we should take a deep breath. We should woosah. We should have some meditative music and not panic with respect to this.
So this is all a part of strategy.
Absolutely.
Here. And you bring up a very interesting point, because you said that we believe, or we know that Trayvon was fighting for his life. And the reason that we know that, Jelani, is because the last person to speak to Trayvon before he died was his childhood friend, Rachel Gentile, who we talked about for a lot of different reasons last week. One would consider her to be the prosecution's star witness. But a lot of people said that she did damage to the prosecution's case because she was difficult to understand, sort of some of the baggage that came along with her presentation, and that she seemed to contradict herself. Can we get past those things to give her the credit that perhaps she deserves as the witness that she is in this case?
I think there's two things. One is the issue that she contradicted herself. We, saw that she said things, and then she just kind of very overtly said why, some things she said weren't truthful, and, they were for reasons that people might understand. She didn't want to cause the family more pain. She, was dishonest about why she didn't come to the wake, because she couldn't bear to see his body. And she said that very emphatically. She said, you got to understand, I'm the last person that saw him alive, spoke to him alive. And so there's the actual element of this, okay, this person's not true, but then there is an emotional content of people saying, this is still a very young person who was put in a situation that none of us would want to ever be in. And then I also think, we've talked a little bit about this. I think that the approach that Don West took may have actually boomeranged and made her seem sympathetic, to someone, because she is someone who is not, polished, and not somebody who's been, overly trained, and someone who clearly does not want to be in this environment. And so you look at this and you say there's this really sharp, professional and established, experienced attorney, and there's this person who's saying, I know what I heard. And I don't think that it's necessarily as harmful as some people think it might be.
And the fact remains that she still stuck to her core story.
Absolutely. I think that what we have to do is we have to remain focused on what exactly is happening here. I'm not impressed with a litigator who has been litigating for a long period of time, talking to someone who may be looked upon as functional illiterate, unable to read script, and able to twist her words. You don't want to, that doesn't impress me. You want to impress me? Take a professional witness and rip them apart. So I'm not really impressed by that. Secondly, he focused on trying to get everyone else on that jury to not focus on the facts. He must have said the term cracker 1,000 times. He must have said to her to suggest that you're calm today, as if somebody has suggested something other to her. But she said some things that in her colloquialisms that I thought was so good. First of all, she said that, that doesn't make any sense, so that's retarded, sir.
Right.
And then said to him, you didn't know Trayvon, or you didn't know him. And those particular things that are items that I hope the prosecution focuses on when you talk about her testimony. What did she say? I know you didn't like that other stuff. The other problem we have is we have an anonymous jury. In other words, I don't know those individuals from Sanford. I'm not able to look at their faces. I don't know what their experiences are. So I don't know if Mr. West feels that he has that type of jury where he actually can attack her and they're not sympathetic.
Well, you bring up a very good point here, and that is we don't know what the jury is thinking, but the fact is we do know that they're all female,
right,
and we do know that 5 of them are white.
Right.
And so while you're able to overcome sort of some of the rough edges of Rachel Jeantel, what we don't know is if they will be able
Absolutely.
to overcome it. I want to bring in this other issue. It's so interesting that for a year now, many have said, protesters have said, George Zimmerman was not brought up on charges because he was a white guy that shot a black young boy. And then the parents came out in a press conference, or their representative on Friday, and said, this is not about race. We don't want to inject race into it, which seemed a little odd to me. But I think Rachel Jeantel reaffirms that it's about race, because all of these miscommunications really is about miscommunications of culture.
Right.
So when Rachel Jeantel, when Don West was cross-examining her, and he said, how did you know this was racial? And she said, because, Trayvon said that the person was following him was as he said, creepy-ass cracker was the term she used. And she was like, well, then he's injecting race into it. But what she couldn't quite get to was the point that through experience, black people understand this. Like, you are in a place where there are lots of white people living. There's a person who is perceived, functionally as white. They've been following you around, and you recognize, okay, this probably has something to do with my skin color. The jury can likely grab that inference, even if these are people who are not necessarily sympathetic to her. They understand what exactly she's saying and what exactly she's implying here. Whether or not they agree with it is something else, but they certainly understand what she was the point she was trying to make here.
In order to interject race, he would have had to say that to George Zimmerman. He was speaking to his friend, his colleague. George Zimmerman never heard that. That's the first thing. The second thing is I've said from the inception of this case, and I'll stand by it, to a lot of criticism, by the way, I said that this isn't about race. It isn't. If we make it about race in Stanford, Florida, you lose that case. Why? Because that is a racially separated part of Florida. You're not going to win that race having 6 jurors.
5 of them
are white. And then you're going to argue this is a race thing. People already think that whenever something happened and you holler race, you're pulling out what they call a race card. What you argue to those women is that here's a 17-year-old child who is in an area that he belongs. His father's fiancée lived in that area, who is coming home doing nothing. And the last time I checked, in hip-hop, the people that are wearing their pants baggy and hooded sweatshirts all don't look like African Americans. They all don't look Hispanic. In fact, a lot of the white population is wearing that to such a degree that they're changing laws now that you can't go to certain beaches in Jersey if your pants are hanging down. So I think that it's more of a culture than a race, and I think that you try it that way.
Let me ask you this very quickly before we run out of time. Of course, there's been no talk from the defense about whether or not they'll put George Zimmerman up on the stand, but the fact is the witnesses or the neighbors have given conflicting accounts. Does this force the defense to have to put George on the stand?
Well, it doesn't, because what it does with that neighbor that indicated the straddling and looking like Trayvon was on top and hitting him in the head to the end of it, it puts forth that self-defense claim without George Zimmerman ever having to take the stand. You can make that argument. All you want to do as the defense in this case is set up your argument. And you have some evidence now to set up your argument. I submit to you it doesn't make a difference, but you do have evidence to do that. So I don't think that he has to take the stand at this point at least.
Okay, we will see. We're going to continue covering the trial. I'm sure we're going to hear from both of you. Jelani, Cobb, thank you so much. Thank you as always, Tariq El-Shabazz. We appreciate your patience there. And as we continue to cover the trial, please do stay attuned to Arise America as we continue in our covering of the killing of Trayvon Martin, the trial of George Zimmerman. Don't go anywhere. We have Arise News Now with Julian Phillips coming up. Have a great day. I'm Debbie Turner-Bell. Bye-bye.